Good morning and welcome to this webinar from HR Advance. Today we're talking to you about how to protect your business from #MeToo. I'm Alison Williams. I'm the Managing Editor here at HR Advance, and I spend my time keeping you up to date with the latest information affecting your workplace. And I do that through the newsletters and ebooks that I send to you with news and information from our Knowledge Centre. Don't forget, you can always log on directly to HR Advance and click on the Knowledge Centre from the homepage to browse all the. So for today, there's been a lot of interest in this webinar because it seems there's a lot of interest generally in the topics of sexual harassment and also consensual relationships within the workplace. And of course, they're two different things, as our guest speaker today will explain. The #MeToo social media tag seems to have really concentrated attention on the topic of sexual harassment, and it doesn't seem to be slowing down. On the other hand, the nation's attention has been concentrated on our federal parliament, which has seen the government introduce the so-called bonking ban in the aftermath of the now ex-Deputy Prime Minister Barnaby Joyce saga. And I'm not even going to explain this saga, as I'm sure you're very aware of it, and I'm sure you're as sick of hearing about it as I am. So with me today is my guest, Joe Murphy. Joe is Managing Director, National Workplace with Australian Business Lawyers and Advisors, the legal team behind HR Advance. Joe is an employment and industrial matters specialist, and he provides strategic advice for both the private and public sector for his clients on discrimination, unfair dismissal, bullying, general protections, including adverse action, harassment, and contractual issues. Joe has more than 15 years' experience in litigation, and he's represented clients in a range of tribunals and courts. And he's also represented clients in connection with public investigations and inquiries, including a number of high-profile inquiries into corruption by employees and public sector officials. So welcome, Joe.
Thanks, Alison. It's great to be here.
Great. Well, just how this is going to run today, I'm pretty much going to hand it over to you as you take us through the minefield, or probably I should say the swamp, of sexual harassment in the workplace. And we're also going to, of course, be discussing how to manage consensual relationships in the workplace. And, of course, you'll be discussing our new policy, which is designed to help employers do just that. So over to you.
Excellent. Thanks, Alison. And yes, look, I'm very pleased to be here talking about this topic because it is not just a hot topic at the moment, but it's a real problem for businesses. And some of the things we're going to talk about today is, well, what is Me Too? Because someone I thought the other day when I was talking about this webinar who would know about Me Too said to me, what is Me Too? And I was a little bit surprised about that because I thought it was a really concise way of describing the current businesses and, in fact, governments and other organisations are facing out in the society and the business environment at the moment. Today we're just going to cover off on issues or the way things were prior to Me Too arriving, some of the laws and regulations and some recent cases and how we go about preventing things or preventing these issues from arising in our workplace, or at least putting in place measures that can help us defend our businesses. So what is Me Too? Well, Me Too, and I think this will come as no surprise to many of the people on the listening to us today, is Me Too really came about a little bit prior to the Harvey Weinstein scandal. Now, Harvey Weinstein, for those of you who don't know, is a US movie mogul.
Yes, heard of him.
He makes movies and funds movies and is well connected in Hollywood and in filmmaking in the US and, in fact, across the world. And as many people will know, late last year, in about October last year, there was an explosion on social media and mainstream media, basically revealing that he had engaged in some inappropriate conduct towards particular actresses and other people in the movie-making business. I'm not going to go through all the lists of high-profile actresses or actors, I should say, a neutral term, actors that have been sexually harassed by Mr. Weinstein, but it's pretty conclusive that what had happened to those people is something that people generally accept occurred. They're not just allegations. They're almost foregone conclusions. But what that has meant is that it's meant that there's been an explosion of allegations that have risen since, and people, you'd have to be living under a rock if you hadn't seen some of the things that had happened here in Australia, let alone around the world. And various high-profile people, whether they be politicians or people involved in the movie-making business, were revealed to have been had engaged in sexual harassment or inappropriate conduct of a sexual nature towards individuals. What it also meant, though, was that people have come out and made allegations that perhaps might not be sexual harassment. This is happening in our workplaces in Australia, and I've got a number of cases at the moment. I can't talk about them in any detail, but they fall into both buckets. They fall into situations where there has been a problem and perhaps the employer could have done more, and they fall into the let's call it a bucket, or the category of claim where a person perceives that perhaps they are entitled to have made a complaint because they were subject to conduct that might or might not be of a sexual nature. So it's really important for today's purposes that we understand when these complaints arise, how they're dealt with, and what you need to look at when you're dealing with the complaints. But as we'll get to, prevention is, as we always say, the best cure. And that's what HR Advance is all about. The focus of that, of the HR Advance product and the HR Advance service is really about helping businesses not just set themselves up, but also prevent the business from facing liability in these situations. So let me just take a step back to prior to Me Too, and it's really important to understand the environment prior to Me Too. The way the world was prior to Me Too was that we had, and we might move on to a couple of slides. Yeah. In the environment prior to Me Too, which is the next slide, we do have, there's just no denying that there has been a history of gender imbalance in the Western world, and in fact, more broadly across the globe. And we had, because we've come from a history, whether it's in the workplace or whether it's home, where women were expected to do certain jobs or certain things, men were expected to do certain jobs or things, we found ourselves in an environment, and we still do find this, that there is a gender imbalance. And it's important to be conscious of that at all stages. It's important to be conscious that industries, particular workplaces, where there is a division from a gender perspective, or there's an obvious gender imbalance in terms of numbers alone, that can create an environment where individuals can feel like one gender is more dominant than the other. And it often happens that it's the male gender will be more dominant than the female gender and I'm not suggesting that that's a natural thing. It's just something that's happened historically. And we know that through a whole range of things that are happening in our society, a number of them in the workplace as well, that there are a number of things being done to address that. Corporations are talking about having quotas on boards to make sure boards are balanced out when it comes to the numbers on genders, where we've got a case in the Fair Work Commission at the moment called the Equal Remuneration Order, where the unions and employer groups are currently discussing with the Fair Work Commission and conferencing with the Fair Work Commission about how the Commission might address pay issues on the gender imbalance basis. And that's really an issue that society is struggling with, but dealing with. It's addressing it, and things are changing, but they haven't settled yet. So it's important when you're in a workplace to remember those things. Then you've got the issue of power imbalance, and that's not just about gender. That's about hierarchy in the workplace or in government. And that's one of the issues that dovetails into the Barnaby Joyce situation, where people are outraged that, an MP who was effectively the boss and, well, the Deputy Prime Minister, in fact, ended up having an affair with one of his staff members. There's that perception, at the very least, of a power imbalance. And the perception of power imbalance is just as important as an actual power imbalance. So it's important that when you're managing your business or managing people in the workplace, that even though you might feel that nobody abuses their power or their position in the organisation, that there will exist at some level and at different times a perception that there's a power imbalance. And so people who are managers and owners of businesses need to at all times be conscious of that power imbalance. They need to be conscious that when they're making decisions, when they're dealing with people, those people will not feel they're dealing with an equal. You might feel that you're treating them as an equal, as their manager or their boss or the owner of the business. They're never, you have to assume that they don't feel that way. And so in doing that, that requires a greater level of caution when dealing with them, a greater level of care in the way that you deal with them, a greater effort in explaining to them what you're doing and why you're doing things, not leaving too much unsaid. And that's where things can really fall apart. So that's really what we've had historically. And those are issues that actually still exist today, of course. Then we've had a history where inappropriate behaviour has perhaps not been raised in the workplace when it could or should have been raised. And there's a whole range of reasons for that. And they do fall back on those, partly on those two first points I raised about there being a gender imbalance and there being a power imbalance. And that is that sometimes people assume, I'm not going to make a complaint because that's just the way things are. Men say those things. Men do those things. Or he's the boss. He can do this. Or she's the boss. She can do this. It's not always men. You know, when it comes to power imbalance, there are instances where a woman in a position of power will abuse that power, and it might ultimately fall into the category of the types of conduct we're talking today.
Do you think Australia's egalitarian culture makes it a little bit trickier here in Australia? Like, we tend to, you know, the boss wants to be seen as one of the gang often. I'm not saying all the time. You know, compare that, say, to an American where, you know, where it's a bit more hierarchical than it is here. Do you think we're setting ourselves up for problems because of our culture?
Look, I think that's right. And that's why I'd said a minute ago that when we're talking about a person who's in a position of power, from a power imbalance perspective, it's really important, particularly in respect of what you're saying, Alison, that that in the Australian culture, a boss, a supervisor, a business owner will sometimes think, so we're all mates. We all go out and drink on a Friday night after work. And they forget about that perception at the very least of a power imbalance. And they think that an employee, well, if this person's got a problem with it, they're going to come forward. And they don't. Because regardless of the fact that they might consider themselves to be friends with the boss, there is still sitting in the back of their mind, perhaps not even in a conscious way, maybe a subconscious way, that there's a power imbalance.
And then, of course, if they do want to all be mates, well, then if you come forward, then suddenly your mates are no longer your mates. So it gets even a bit more complicated then. That's
right. I mean, there is that, and it's interesting you do raise that, because I do think, you know, for managers and leaders of businesses, there's an element of leadership that requires you to really take a step back from those personal relationships. And, you know, obviously we don't know a lot about how things evolved between people like Barnaby Joyce and his new partner, and all of the other scandals that have preceded that scandal, because there are many. But it'd be interesting to understand, you know, if you did, you know, as a person who studies these things and understands, and, you know, or gets an understanding of the human behaviour after the event, you know, whether or not those did arise out of circumstances where there was a friendship and a power imbalance at play, and ultimately things evolve in a particular way. And we are going to talk today a little bit about, you know, how people you can have consenting relationships in the workplace, but the current environment means that we just need to be very, very careful about, as leaders and owners of businesses, about how we manage things now, because the environment where people are hesitant to make a complaint has largely dissipated, and people will now make complaints about things that are not necessarily unlawful. And that's why today's helpful, because we're going to talk a little bit about legally when things are triggered.
Okay.
And that's somewhat helpful. From a sexual harassment perspective as well, historically, there are instances where people are overt in the way that they deal with others in from a sexual harassment perspective, or from a discrimination perspective, and that we still get those instances. I have to say that, over the 18 years that I've been specialising in employment matters, I have seen an evolution where businesses are managing them better now, but mostly still not good enough.
Okay.
And again, we're going to come to prevention a little bit later today when we get to that. But from a sexual harassment perspective, it still shocks me to find that there are people in the workplace who still engage in very overt acts of sexual harassment.
I agree. It really shocks me too. You think with so much media exposure of these issues, it shocks me. However, here we are.
Exactly. And after we had the Sex Discrimination Act at a federal level come in 1984, and in New South Wales we had a Anti-Discrimination Act in 1977, and both of those acts contain anti-sexual harassment provisions and anti-discrimination provisions. And even though we're now moved on many years, many decades since those pieces of legislation have come into play, we are still seeing these instances. And that's why when you couple that history with the current environment of Me Too, it is really incumbent upon businesses now to step up and to really take a look at whether or not they're doing enough to protect their businesses, because you can do enough to protect your business. So what are the rules? I think it's important. Let's start with the rules. So firstly, we've got the discrimination laws, and some of the complaints that have arisen in publicly, you can tie them back to perhaps the gender imbalance environment. As I said earlier, it's not always about gender. I mean, we did have some. It can be gender on gender, or it can be female on male. But the historical one is the majority of the cases tend to be male discrimination against female. And from the Sex Discrimination Act perspective, it's probably helpful if we just look quickly at the Federal Act. And there's, of course, there's a federal piece of legislation called the Sex Discrimination Act 1984. Then we've also got the state and territory legislation in each state and territory, and they're all very similar, not necessarily identical, but they all operate in a very similar way, and they're all managed in a similar way by businesses. So if you are doing all the things we're going to talk to you today about, then you can manage your risk across all of these pieces of legislation. But just looking at sex discrimination, now that's defined in the Act, in the Sex Discrimination Act, and it's defined as follows. A person discriminates against another person on the ground of sex of the aggrieved person by reason of the sex of the aggrieved person, a characteristic that appertains generally to persons of the sex of the aggrieved person, or a characteristic that is generally imputed to persons of the sex of the aggrieved person. If the discriminator treats the aggrieved person less favourably than, in circumstances the same or not materially different to, the discriminator treats or would treat a person of a different sex. So generally put, if you treat a female differently to a male in the same circumstances because they're female, and that can be directly, indirectly, or directly because they're female. It might be because there's a particular characteristic that pertains to females. And when we talk about indirect discrimination, there's a range of examples that we give, but we always give the classic one of the old police policy of only hiring people of a particular height. And even though that wasn't directed at females, it was discovered later on that, the height level that was picked was one that would generally capture a greater group of men than would women. And on that basis, they said, well, it indirectly discriminates against women. And accordingly, they got rid of the height policy because it really didn't have any reasonable basis. And it also a characteristic that generally imputes to a person, and that is if you discriminate against someone because you think they're female, then that's still discrimination if it turns out they're not female. Now that applies, those concepts of discrimination apply across all of the types of discrimination, whether it be race, religion, nationality, political opinion, all of those things. But for the purposes of today, we're just looking at sex. And the reason I raise this, because we're mostly talking about sexual harassment today, I'm going to talk about the definition of that in a minute. But the reason I raise this is because the claims that are arising today, some of them seek to characterise the claim on the basis that a particular female employee in a particular environment has behaved in a particular way or endorsed behaviour or tolerated behaviour over a sustained period because they needed to fit in to a male-dominated working environment. And there's a case I'm going to talk about today where that issue was raised. And that is important because I actually think that there are some claims that could be sustained on that basis. I don't think there are a lot. I think it's raised a lot more often than it should be. But I do feel that there are particular environments and particular times and particular scenarios where it could be that a female may not have raised a complaint or may have appeared to have endorsed behaviour and tolerated over a sustained period on the basis that it's a male-dominated working environment. But I do feel that they only fall into a particular category. I don't feel that if you're you happen to be the only woman or one or a limited number of women in a particular working environment, if you engage freely in the behaviour, using inappropriate sexual language, sending inappropriate sexual images, and generally engaging in the inappropriate behaviour in the workplace, I don't think the male-dominated work environment complaint or excuse for their behaviour is going to fly, in my view.
Okay.
Yeah, it's. I think there are shades of grey between those two scenarios, but I just don't think you're always going to get away with that. And that's one of the recent, as I said, one of the recent cases I'm going to talk about is where that occurred. Now, sexual harassment is the bigger one, of course, and the one where. Before we move off that topic, I'll just quickly say, in relation to sex discrimination, I raise that also on the basis that it's really important to understand that if you do have a very small number of females or one female working in an all-male team, it is important that you do make a conscious effort to make sure that they are, being exposed to an appropriate working environment and not one where there's inappropriate banter or inappropriate sexual banter. Look, frankly, even if it's an all-male working environment, they shouldn't be engaging in inappropriate banter or inappropriate sexual banter. But it is really important that where you do have that gender imbalance, and there might be a power imbalance as well, that that you're conscious of those employees entering into that environment. But having said that, if you have in place all of the measures we're going to talk about today, then really you shouldn't need to be focusing specifically on single or very small numbers of women working in male-dominated teams. So from sex discrimination to sexual harassment, in the same act, the Sex Discrimination Act provides a definition of sexual harassment, which is very different to the sex discrimination definition of sex discrimination itself. And that it is as follows: a person sexually harasses another person if the person makes an unwelcome sexual advance or an unwelcome request for sexual favours to the person harassed, or engages in other unwelcome conduct of a sexual nature in relation to the person harassed, in circumstances in which a reasonable person, having regard to all the circumstances, would have anticipated the possibility that the person harassed would be offended, humiliated, or intimidated. And then the Act actually goes on to provide particular features that you should take into account. And for the purposes of the circumstances I've just described, you take into account a person's sex, age, sexual orientation, gender identity, intersex status, marital or relationship status, religious beliefs, race, colour, national or ethnic origin. And you'll also take into account the relationship between the person harassed and the person who made the advance. And you'll also take into account any disability of the person harassed and any other relevant circumstance. So all of those features are things that
I can hear people out there just going, "Oh, that's too much. I can't keep this all in my head. How do I do this?" It is
too much. It is too much. And that's why when you have your systems in place, you don't need to turn your mind to those things.
Yeah.
If you're managing your workplaces in the manner in which I'm going to talk to you about in a minute, then you don't need to worry about these complex things. But I think it's important. I just wanted to point them out because they are complex and they do take into account all these things. I mean, when we talk about that definition, there's a couple of important things. One is welcome or unwelcome conduct. And the other one is there's also a reasonable person test as well.
Yes.
And one of the things with the current Me Too movement is that down the end where there are claims being made that are perhaps don't necessarily fall into the unlawful category because they're not really sexual harassment or not really sex discrimination. It's really, that's when you'll find yourself looking into that information or that particular detail. If you're up the other end of the spectrum, then you'll hope that you've done everything we're going to talk about today, including having your policy in place and the new policy that HR Advance is launching and making available for managing relationships. And it's not just the Barnaby Joyce situation which has led us to that. It's a whole range of scandals that have arisen following the Me Too.
Well, yes, because I am interested that we have gone down that path, Joe, because I can remember talking to you probably only about a year ago, and like, no, we're not going to have a policy on that, and now we do. So yeah, we'll find out more about why we've made that change ourselves, I think.
Yeah, look, Alison, maybe we loop back on that because that is an interesting discussion, and it's one that I think we have when we talk about the policy and why people might now need to be thinking about having that policy. But what I might do before we get to that point is just talk about some of these cases.
Yeah, sounds good.
I'm sorry, when we talk about the rules, before we leave this point, there are also general standards of behaviour. And we've got that up there because we think it's important that whilst you might technically not have a discrimination claim or technically not have a sexual harassment complaint on your hands, general standards or setting the general standards of behaviour in your workplace is really important, having regard to societal standards as well, so that people, when they do work come to work and work with other people, they know they're going to be treated fairly. They know they're going to be treated fairly based on merit and not based on their gender and clickiness in the workplace and unfair treatment generally, because a very large chunk of claims are made because people fail to meet general standards of behaviour. Now, sure, they're going to fail legally, and we get lots of those claims, and clients are never happy about the fact that we tell them they're going to win their case because they've already spent their money on legal costs. They've already headed down that path of having to defend a claim about something that's a general standard, breach of a general standard of behaviour, rather than something they've actually done that's wrong, legally speaking. They've just done something that might be wrong by the person, or at least perceived to be wrong by the person. So I think general standards of behaviour are important, and I think they do sit there as a sort of an unwritten code of rules in society. So turning to our cases, and this is a recent case, and I thought we've picked up a few recent cases. It was in, as you can see here from the slide, it's a 6 December case, and it's Wilson and Anglo Coal. And it's quite an interesting case because it involves gender imbalance, power imbalance, it involves allegations of sexual harassment, it involves an employee who made a complaint in an environment where there were no independent witnesses. So it was a he said or a she said, he said. And I really think that's important because we get lots of she said, he said situations. And we get, when it comes to investigations, some people form the view that, well, if it's one against the other, it's a neutral outcome. And there's nothing we can do about it because there's no independent way of breaking that deadlock between those two people. And that's not the case. It is very rare in the 18 years that I've been specialising in this area, it is very rare that I've come across a case where we haven't been able to make a finding one way or the other. And that's because you look to the evidence that surrounds the circumstances of the allegation. Now, in this particular case, it involved a female trainee who I think commenced work at about the age of 19 with Anglo Coal, and a fellow called Vincent Wilson. And Mr. Wilson was a more senior employee working with this young lady. And she decided to resign one day. And she resigned, and then a number of weeks after her resignation, she was the subject of an exit interview, as good businesses do, conduct their exit interviews. Better to know than not. All feedback is good feedback. And except maybe in this case where they interviewed her and she made a complaint that in fact what had occurred to her was that Mr. Wilson had sexually harassed her, and she made a number of allegations, including an allegation that he patted, slapped or otherwise touched her on the backside, and had made a statement to her to the effect that she could stay with him or vice versa. They could live together as long as she liked gardening, sex and helping around the house. And of course, the reference to sex was the inappropriate comment. There were no independent witnesses. And there were some other allegations, but those two allegations just point to were actually allegations that were found against him following an investigation. Now, when you read a decision like this, you don't, as a person who didn't act in the case, you're not privy to everyone's evidence. You can only go by what's in the decision. So what the decision says is that there was an investigation, and in investigating whether or not this occurred, because it was one-on-one, they had to go more broadly, and they interviewed, I think, 7 other employees. And it was almost like a little bit of a witch hunt type investigation. I'm not suggesting it was a witch hunt, but it seemed like that the way the decision's written, in that they went about interviewing other people and saying, has Vincent made inappropriate comments before? And, they were trying to find other evidence. Find the evidence. Yeah. So they're trying to find supporting evidence. Is this allegation true? In which case they're looking to things like tendency and coincidence evidence that suggests that maybe he did engage in the conduct and supports her version of events. I have to say that when you read the evidence that was obtained, none of it really suggests that he actually did it. There are some disparaging comments about his work ethic and perhaps his worth to the business, but there wasn't anything said about him actually having engaged in the conduct itself. But nonetheless, they still made a finding that he had engaged in the conduct, and they terminated his employment. Okay. Now, she was already leaving the business. And I think from a business's perspective, it is important that just because the young lady left didn't mean that they should not have taken action against him if it was appropriate for them to find that he had engaged in sexual harassment. But what had then happened was, of course, he filed his unfair dismissal claim. It came before Commissioner Spencer, and Commissioner Spencer made a finding that, in fact, upon hearing all of the evidence, including the evidence of the young female trainee, that she thought that they'd made an error in finding that he'd engaged in the conduct. And in fact, she'd made findings that her credit was in question. And in doing so, found that he had been unfairly dismissed as a result of that. And I thought that was really interesting, that the business had almost overreacted in terminating him for this. And I thought it was a really good example of the he said, she said situation where they got it wrong the wrong way. So the commission said that at the same time, even though she had raised also in connection with her behaviour, which was found to have been inappropriate. So while they were conducting their investigation, they discovered, in fact, she had engaged in sexually inappropriate behaviour. making inappropriate sexual comments and the like from some of these witnesses. The Commissioner said there's a couple of things to say about it. One is that the decision here is not to be one suggesting that it endorses the extreme behaviour of people like Harvey Weinstein. And in fact, she even named Harvey Weinstein. It seems to come up a lot. I've seen it in a number of letters of people making complaints.
I have a feeling we'll be hearing that name for a few years to come.
I think that's right. I think that's right. So said that nothing should be taken the decision to construe that to be construed to be supporting the inappropriate conduct of people in the workplace. Now, I don't think that could be said, but it's interesting the Commissioner said that. So I think she really wanted to say that you still need to be careful about things like sexual harassment. But in this case, you also need to be careful about not overreacting, not going too far the other way. But it might be cold comfort to those businesses that now find themselves receiving claims from time to time. I know the clients I deal with that find that are certainly of that mind. So we've got this next case, which is Philip Parker and Gary Cricks. So in this particular case, this was an appeal. And I thought, again, another recent case came down on the 22nd of January. So I thought, let's talk about some recent cases. And this particular case, I thought, was important for a number of reasons. It's a good example of a case involving, I've called it violence and sexual harassment. And it wasn't an act of violence. He didn't physically come into contact with the employee, but there's a mix of, sexually inappropriate behaviour and threats of violence in this, regardless of whether or not they meant them. And I've included, and so if I could just talk about what the happened here. There was a business manager at a car dealership at Gary Cricks, and he made remarks to a 21-year-old female sales employee, a trainee. So again, we've got another trainee, but this is the flip side. And what else is interesting about this is also a Commissioner Spencer decision in the first instance. Yeah. So we've got our last case, which was Commissioner Spencer finding in favour of the employee who'd been dismissed. In this case, Commissioner Spencer had heard the case at first instance on appeal. And during that, the business manager was alleged to have said to the employee that if you ever call me that finance guy or that business guy, so she'd obviously referred to him as in a general sense, I will backhand you. Even if you are a girl, I don't care.
My goodness.
So that was one statement. The second statement that he made was that after the trainee told him that a customer was making her feel uncomfortable, he just said to her, "Just show them your tits and you'll be fine." So we've got a mix there of, in fact, we've got the holy trinity of inappropriateness. We've got a threat of violence with the backhander. We've got the sex discrimination comment about you are a girl, even if you're a girl, I don't care. And then you've got the last comment, which is the sexually inappropriate one about the reference to her breasts. They dismissed him for gross misconduct, and they found that it breached their sexual harassment policy. Now, I thought I've already pointed out that the first incident, and the Commission pointed this out as well, the first incident involved a threat to use violence, and the second was uninvited conduct of a sexual nature involving a derogatory comment. And it offended her, and they made that finding that it did offend her. So in that case, I just thought it was a really good example and a flip side to the other one where the same commissioner, hearing a very similar dynamic between a trainee and a senior employee, male to female, had made that particular finding. So Commissioner Spencer's not swinging one way or the other. She's just making a decision based on the facts here. And of course, the full bench backed her up and found in her favour in that one. We do have a final case that I wanted to talk about. This is a really important one. It's one that HR Advance has previously reported about. So thank you, HR Advance, for, in fact, Alison, I think you wrote the article.
Oh, probably did.
You did. It's a really important one. It is also reasonably recent. It's a 2016 decision. But I thought it was important to get a recent decision that included a number of factors that are important to businesses out there, and that is the vicarious liability of businesses and the joint and several liability of offenders and their employers. So I'll explain that when we talk about this case, but also if I could just quickly turn very briefly, I'm going to bore you again with a legal definition, but I think it's important, and it's only brief. It's a little bit briefer than the other definitions. In the Sex Discrimination Act, vicarious liability is defined as follows. Where an employee or agent of a person, in connection with the employment of an employee or with the duties of the agent as an agent, engages, an act would, if it were done by the person, be unlawful, or an act that is unlawful under the act applies in relation to that person if that person had also done the act. And then, so it's effectively what it's saying is that if an employee engages in sexual harassment or sex discrimination, then the employer, it is taken that the employer has also engaged in that conduct. So if an employee or an agent, just remember it's broader than employees, engages in the conduct, then it is taken that you have also engaged in the conduct if they do that conduct in connection with their duties.
Do you think that's where a lot of employers perhaps don't get that nexus? They think it's nothing to do with me.
Absolutely.
Yeah.
I think they think that in society, individuals should be responsible for their own behaviour. If you engage in the crime and you're arrested, I'm not going to jail for you.
Yes, exactly.
This is civil law. This is a particular code of behaviour that society has agreed upon since 1984 in this Act. And it says, and the successive governments have agreed, if you're an employer of someone, you are responsible for their behaviour. It does include a carve-out, though, and this is where our advice today helps, and that is, however, you are not considered to have engaged in that behaviour done by the employer or agent if you can establish that you took all reasonable steps to prevent the employer or agent from doing those acts.
Okay, that's pretty clear.
Yes. And that's really what today's about, is about reasonable steps and our new policy that we've launched. And so if I just talk quickly about this case, we've got our labour hire employer in this case of WSTU v JKL Queensland Proprietary Limited and others. There are a number of respondents. And in this particular case, we had 3 respondents. We had 4 parties. So we had the applicant, the complainant, then we had the labour hire employer who employed the complainant. Then we had a caretaker of the hotel and the hotel in that order. They were the first, second, and third respondents. And what was interesting in this case is that the employee, or sorry, the complainant, I should say, who was a young lady, joined all of these respondents and sought that they all be made responsible for the conduct that was inflicted upon her by a particular individual. So what had happened was, in fact, there was a connection between the first and third respondents because the director of the labour hire company, as the first respondent, was also a director of the hotel. And he ran this labour hire company to provide labour to the hotel. And employing the employee, the complainant, he offered her accommodation in the hotel. Yeah. And he said to her, you can stay in the same apartment as the caretaker. Now, that was a fatal mistake, I think. Requiring 2 employees to live together in that environment where they're in an apartment together, separate bedrooms, but nonetheless, they were sharing an apartment. I thought that was really quite problematic. I know there are circumstances where employees will stay together. I know we've done it before. I've stayed with my boss in joint accommodation. It's a good way to cost save.
That's right. When you go to a conference or something like that.
But where you have a gender imbalance, you have a power imbalance, and you have a new employee, in my view, this was a fatal decision on behalf of the employer. And the owner of the hotel, who were one and the same thing in one view. The applicant agreed, but then on her first night in the hotel, she woke up and this caretaker was sitting on the end of a bed naked. And I don't go into too much detail, but he did touch her, and he did attempt to remove her underwear. And then when she rejected him, he said he left, and he said to her, I'll let you get changed. And then he said, this can be our little secret. And that was his way to exert some control over her. Now, it was such an extreme event, and in fact, a criminal event. But this is not a criminal case, of course, but had he been charged, there's no question he would have been convicted if those facts were established. He left the room, and she then eventually brought a claim, sued all three respondents. Now, the caretaker didn't turn up at the hearing. So his evidence, whatever she said about the way he behaved, was ultimately accepted because it was uncontested. And I have to say, the businesses out there that are listening now, it's very common. I shouldn't say it happens all the time, but it happens. It's very common for an offender to go AWOL. They just go missing. They quit their job and they leave. It happens a lot. And what that means is that you will be stuck with defending a case which is indefensible. And so her evidence went into evidence. Her version of events went into evidence and was accepted without any exception. And so what the employer tried to do, what the hotel tried to do, is it tried to run an argument that it may have fallen outside of their scope of their liability. And what the tribunal said in that case is that it doesn't matter how she came to be in the unit, the apartment that they were living in. There was a general prohibition under the Act. And section 118 of that Act, in fact, says a person must not sexually harass another person. And they said the prohibition is not limited in relation to a place or a circumstance. Once the Act has been contravened, the vicarious liability of the provision set out in the Act will be engaged if the contravention occurred in the course of work of a person's work. It is irrelevant to submit that, as the hotel had done, or they claimed, that the applicant, the complainant, was the second respondent's guest or the caretaker's guest. So they tried to argue that she was his guest and that they're not liable for his behaviour, and that she was not in any way connected with the hotel or the caretaker's work for it. Now, the caretaker was employed as a contractor to the hotel. So there was this complex arrangement where we had the applicant employed by the labour hire employer. The caretaker was self-employed by the sounds of it and contracting to the hotel. There was a connection between the labour hire provider and the hotel, so it gets all messy. But nonetheless, they just said, we don't care about any of that. At the end of the day, he was engaged as an agent of the hotel. They were at work. They were on the work premises, and there was sufficient connection between them and the work premises. But the significant thing about this case is not because lots of businesses out there are going to find themselves with lots of people staying overnight. In fact, it's probably a rarity where you'll find outside of the hotel industry that people are staying at work very often, although you will have sleepovers and the like. But for the vast majority of listeners, the two important points here are the vicarious liability point, and that is you are, unless you demonstrate that you've taken reasonable steps, you are liable for the conduct of that person engaging in that conduct. And secondly, the award of damages in that case was $313,000.
That is a large sum.
It is, and it demonstrates that there is an increasing tendency for, and we could spend all day talking about cases if we went away and grabbed all the cases we know about over the last 10 years. There is an increasing award of, or there is an increase in the award of damages in these types of cases because courts and tribunals, like the rest of society and the Me Too movement, are getting sick of the behaviour, the overt behaviour of individuals. But if that business was able to demonstrate reasonable steps, quite possibly could have defended it outright.
Which is where we now move on.
It is.
So What can we do? What can employers do?
Right. So the first thing is that one of the things that we haven't historically talked about doing, and that is cultural review. Now, what I mean by that is really getting an understanding of what's okay in your workplace. Everyone who's listening today probably has the HR Advanced policies, or some of them, and hopefully some of them at least. But you've got to look beyond your policies. You've got to look at what is our culture in the workplace. And I really think it's important that you do that cultural review. And there's a whole range of other things we can talk about today if we had time, about how you can, enhance the performance of your business through a cultural review. But for the purposes today, the cultural review, or an aspect of the cultural review, should focus on whether or not people are behaving appropriately in the workplace. And I really would recommend that to businesses, that they get that cultural review if they can. But, and certainly if they need to contact us about that, I can help them with that. I wouldn't be doing the cultural review. Law firms don't generally do the cultural review, but we know organisations that do that. Now, that might be a bit too fancy or a little bit too much of a stretch for businesses. So it's really important that you focus on the next three things that we're going to talk about. The first one's the policies. And one of the questions we've had today in advance of the session is, what sort of policies, or what policies do we need? And the answer is, well, the absolute minimum is that you've got your code of conduct. You want to have either within that code of conduct or another policy about sexual harassment in the workplace that covers off on sexual harassment, covers off on sex discrimination and other forms of discrimination. You want to have, either as part of your code of conduct or part of your policy suite, a grievance policy. You also want to have, and that grievance policy, by the way, needs to have very clear provision for people to make complaints within the organisation, and where it goes right up to the top of the organisation. And you might be looking at situations like that have hit the media recently, like Tim Warner situation, where the CEO is involved in the conduct. There needs to be an external channel for people to make a complaint.
Okay. And
in fact, if you WorkCover New South Wales, or sorry, they're called Safe Work these days, their safety division will, when investigating a grievance policy, they will look at specifically whether or not you can go outside the organisation to the board or someone else. So you do need to have that channel, and it needs to be that employees understand that if they need to make a complaint about the boss, they've got somewhere to go that's independent and trustworthy. Many organisations that are international, so a lot of Australian businesses, will have perhaps an international ethics and compliance hotline that includes an ability to make a complaint. Now, not everyone's got the privilege or the headache, depending on which way you look at it, of being part of an international organisation, but I just throw that out there, that you need to have an external channel for complaint.
What if you're a small business? What would a small business do in that sort of situation?
It does become more difficult, and there is an element of practicality. So there is a point at which there are circumstances where there may not be an obvious channel for someone. But if you're a small business and you've got a board, maybe the board, but if you don't have a board and there's just a very, very small business, then it might be that, and people might not be too pleased to hear this, that you suggest that they might be able to go to an external provider if you're willing to pay for it, or one of the regulators. And I have seen people write in their policies, if you've got a complaint about this, you can go to Safe Work. If you've got a complaint about this, you can go to the Fair Work Ombudsman. If you've got a complaint about this, you can go to the Fair Work Commission when it comes to bullying. Now, some people might not be happy about putting that in their policies because they're inviting a complaint that becomes a legal process.
That's right.
But if you are talking about a very small business, and you do want to be able to hold your hands up at the end of the day and say, we're defending this claim and we've done the right thing, and in fact, we didn't have anywhere to send anyone, so we said, go and see the regulator. It's not a bad look. It's just that if you can have an alternative person to go through, you don't want it to escalate to a legal stage. And if you're a small business, you certainly don't want a heavy, like, Safe Work involved, when it might just be a small issue, you can be resolved quickly. Yeah. It will cascade in a complainant's mind if they go to an external body. Now, what else you need in terms of policies? We'll come to the new policy in a minute, because I think we'll have a broader discussion about that. But those are really the central policies you need when you're within your business managing this particular issue. There's lots of policies you need outside of that, and in fact, an HR Advance has all of them. for example, when you're conducting investigations, you might have a policy around investigations, and that might be part of your grievance policy, or it might be a separate policy. But you'll also need to make sure you're covering off on workplace surveillance, and because you need to be able to look at people's emails, and so there's a whole range of policies out there that we can talk about today. But enable your business and enable it through policies. And of course, this leads to a broader discussion about the way HR Advance is set up with policies and its contracts and the like. And you need your contracts from HR Advance as well to go with your policies to make sure that they're not contractual, but they're able to be relied upon. The second one is training. This is one where businesses fall down on significantly, because I think it's rare that I come across a business that doesn't have any policies. Some of the policies aren't great, but of course, I'm not talking about the ones on HR Advance because they're fantastic. But the training training piece is a really, really important one. And if you have your policies but you don't have your training, you're not going to be able to run a reasonable steps defence. You must have training. You must have a form of training. Now, it might be face-to-face. It might be an external provider. It might be an internal provider. It's got to be a reasonable quality of training, and you've got to keep records. You've got to keep records of who attended, the training you conducted, and follow up people that haven't attended to make sure that they actually attended. Now, some businesses will do online competency training, competency-based training. They'll get you to read the policies, and then they'll test you with 4 or 5 key questions about the policy to demonstrate that you've read and understood the policy. It's a matter for businesses how they go about doing that. We do a lot of training for businesses in relation to bullying and harassment, sexual harassment, inappropriate workplace behaviour. And that looks great because we bring along our pack that we deliver to the training. Employees sign on, they get told what's bad and what's good, and they're told to behave themselves and what the ramifications of them not behaving themselves. So you really get that second limb of reasonable steps.
Well, I think it also brings out that the misunderstandings that we mentioned earlier, that what one person's concept of reasonable behaviour might be actually not reasonable at all. So that's where you're really getting to the heart of that, if you can train people on it.
Yeah, look, absolutely, because you just can't. I know you want businesses want people to just behave, and they expect that civil human beings behave
and do their job.
Yes. And sometimes they're doing neither.
Yeah.
And that's why it's really important that you just don't want to get caught carrying the can for someone else's behaviour. You do not want to get caught for that. There's nothing worse than someone like this guy who engaged in criminal behaviour in this case we were just talking about, and you were running an honest business and you thought you were doing the right thing by giving this young lady a place to stay, and in fact you put her in a room with a sexual predator. And all you had to do to defend yourself was make sure you had your policies, make sure you trained the people in that. That's the first 2 steps. And the last one I've got here is enforcement, because one of the things is, and this happens more often than you think, if you've got people engaged, if you've got policies and you conduct training, but then you've got people who engage in behaviour contrary to that, and it's come to your attention, maybe not directly, not through a formal complaint, but it's come to your attention that the conduct or the culture of people in the workplace is a bit loose, a little bit inappropriate, then later on, if you haven't chased down that conduct by making further inquiries and maybe even conducting an investigation, it might later be said that, well, it's great you had policies and training, but at the end of the day, this behaviour went on and you were on notice of it. Maybe not formal notice, but there was enough there for a reasonable person to go back, or a reasonable employer to go back and actually make further inquiries and enforce the policies. And that means also when you find out about the behaviour, you need to implement punishment that's commensurate with the behaviour. And I've had cases where employers have an employee who's a very good employee, very productive, very effective in terms of the business side of things. But it turns out that they sexually harassed someone and they were given a pass. And then later on, they've engaged in the behaviour. And then you take the action against them to terminate their employment. At that point, you've compromised yourself because the complainant has gone off and taken legal action themselves, but you've endorsed the conduct in the first instance. It's going to be problematic if you don't implement appropriate sanctions for inappropriate conduct. And look, to be honest, when it comes to sexual harassment, you have to seriously work backwards from dismissal. You have to think, is dismissal the appropriate remedy here? And then you almost have to rationalise in the current environment why it's not. Because if you don't implement the policies and the training that people have been given and enforce them, that later could be seen to be a condemnation of the previous behaviour, and that you haven't taken some reasonable steps to address the behaviour, particularly if the person who's later dismissed or later under investigation has previously engaged in the conduct and it wasn't actioned previously. And I can say I've come across a range of situations where that's occurred. So it's really important. But, and I raised this case earlier when I was talking about the Anglo case, the Anglo coal case, that's an example where an employee just went a little bit too far. They were trying to be thorough and ultimately just went too far. What they should have really done, I suppose, in retrospect, and again, I say that, you know, we don't know exactly what went on in that case because we haven't seen all the evidence, but based on the decision, the employer probably should have just spent a bit more time closing out why it wasn't sexual harassment, and maybe put him through some training, and made sure that he was across the policy and the like. Because I think they were being cautious. I think they were being cautious in the current environment. They thought, we're going to have to action this, we're going to have to send a message. And they went that little bit too far.
And that's really every employer's nightmare, isn't it? Where they think that, and because employers do feel a little hamstrung by all the noise around this at the moment. So it's really good to get this very clear-cut strategy of, policies, training, enforcement.
It is.
Well, talking of policies, HR Advance has a new policy, launching it today, in fact. So can you tell us a bit about it, please?
Yeah, look, it's businesses, as you say, would find themselves a bit wedged, a bit conflicted, a bit, pardon the pun, conflicted, but they might find themselves a bit wedged. And so what we've done in conjunction with HR Advance is how do we help businesses manage this issue a bit better? Because the reality is that you can't really, I mean, I know we talked about the Prime Minister's policy, the bonking ban. The bonking ban. That, of course, some of the comments of other MPs have been that, well, it's not enforceable. And they mean that in a range of ways. One is, we can't monitor it. And that's right. You can't go about now policing people's relationships in the workplace. You just can't. And we're not suggesting you do that. Equally, the reality of our world is that lots of people meet their partners at work. Lots and lots of people meet their partners at work, including some of the members of the various tribunals and courts that we appear before over, in relation to these matters. So you're going to get a cross-section of views about the appropriateness of people engaging in relationships, romantic relationships in the workplace beyond the platonic type. So what we've done is we've created a policy that's tried to create some balance and put people on notice when they're in those relationships that they must come forward in certain circumstances and make various declarations about it. Now, that's not an invasion of privacy. It's not a breach of the privacy laws. What it is it's saying to people, you can have your relationships if you want, but when there's a situation where there's a power imbalance, one person works for another person, or there's a family member in the workplace, we've taken this a little bit beyond just romantic relationships. This is also about managing personal interests in the workplace and managing favoritism in the workplace. And when we look at situations like the Tim Warner, Amber Harrison case, where they had a consensual relationship in the workplace, and that's okay. It's not for us to judge Mr. Warner morally if he was cheating on his wife or not, or likewise Ms. Harrison, whether or not she was cheating on a partner or not. It's not for us to judge that, and that's not illegal. Moral breaches are not unlawful. equally, you've got to be careful not to be judging people morally in the workplace, because then you can attract liability for judging someone purely on a moral basis. What this does is, though, it sets a range of rules for the workplace about how people, or when people should come forward and say, look, I'm just letting you know. It's not a public declaration. It's not announcing it to the workplace. In fact, the problem with these situations is that just about everyone in the workplace knows, except the people that should know.
That's right. Yeah. Yes, exactly.
And what happens is the bosses feel like they've got egg on their face because the CEO or the CFO or whoever is in the relationship at the senior level, I say CEO because it was Mr. Warner, it could be anyone, it could be a line manager. But everyone else knows about it, and they all think it's unfair. They all think that there's an imbalance, whether it's just between them and this couple or between the couple. And so it's important that perceptions are managed around that. It's important that risks are managed around that. It's important to understand that when people engage in a relationship in the workplace, that there are responsibilities to the employer to make sure that those perceptions are being managed and that the employer is given a say in that. Now, the policy also helps employers manage that and gives them a discretion about how they manage it. So it's really important that you don't, let's say in the Tim Warner and Amber Harrison case, or let's say in an environment where you've got a more senior male and a less senior female, that you take one of them and treat them adversely. So I think I'm very happy with where the policy's at. I'm happy to take people's comments about questions. We can always, one of the great things about HR Advance is we listen to our subscribers and we make modifications where we need to. But I think we've done a reasonable job of helping people manage that issue in the workplace.
That sounds fantastic. And I really encourage everybody to log on to HR Advance and download that policy, or certainly our subscribers anyway. Look, we probably have run out of time for questions, Joe, but we were hoping to take a few, but any that you're able to answer perhaps afterwards, we might just do a bit of a Q&A up on the website.
Great idea.
Okay, yeah. We'll do that. Well, thank you so much for listening today. I think if you're like me, you will have taken a lot from that webinar, and very much, again, thank you, Joe. Want to show you tell you our appreciation for being with us today.
Thanks, Alison.
So please feel free to drop us a line at customerservice@hradvance.com.au if you have any follow-up questions, and make sure you log on to HR Advance for practical management of your HR work. And at the end of today's presentation, you will be receiving an email with the video so you can revisit it at any time. Thank you for listening.